The opinion of the Court in number 866757 will be announced by Justice Scalia.
This case, Coy versus Iowa, comes to us on appeal from the Supreme Court of Iowa. The appellant was convicted after a jury trial of 2 counts of lascivious acts with a child. At trial, the state made a motion pursuant to an Iowa statute to place a screen in the courtroom during the testimony of the 2 complaining witnesses, both of whom were 13-year-old girls. The trial court allowed the use of the screen, which was positioned between the appellant and the 2 witnesses, so as to permit appellant to see the witnesses but block him from their view. Appellant argued that the screen violated the Sixth Amendment's guarantee of a face-to-face confrontation and violated due process. The Iowa Supreme Court rejected these arguments. We reverse on Confrontation Clause grounds. The right to face-to-face confrontation has ancient roots, although our opinions have discussed it less frequently than other more complicated aspects of the Confrontation Clause, such as the admissibility of out-of-court statements. But both ancient and modern sources suggest that a face-to-face encounter, as the words of the clause suggest, is an important element of a fair trial, which serves the goal of assuring the integrity of the fact-finding process. Today we reaffirm the core meaning of the Confrontation Clause. It is difficult to imagine a more obvious or damaging violation of the confrontation right than the screen in this case, which was specifically designed to prevent the witnesses from seeing the appellant. We do not decide whether exceptions to the right exist, since any exception would require more than the legislatively imposed presumption of trauma that was the sole justification for use of the screen here. There was no individualized finding that these witnesses needed special protection. We believe that violations of the confrontation right may be harmless beyond a reasonable doubt, and rather than decide whether the error here was harmless, we leave that issue for the court below. Justice O'Connor, who joins the opinion, has filed a concurring opinion in which Justice White has joined. Justice Blackmun has filed a dissent in which Chief Justice Rehnquist has joined. Justice Kennedy took no part.
The opinions of the Court in 2 cases will be announced by Justice O'Connor.
The first is number 86-2000, United States versus Kozminski. This case comes to us on writ of certiorari to the United States Court of Appeals for the Sixth Circuit. In 1983, 2 mentally retarded men were found living and working on a Michigan dairy farm in squalid conditions and in relative isolation from the rest of society. Dairy farmer Ike Kozminski and his wife and their son John were charged with violating Section 1584 of Title 18 of the U.S. Code, which makes it a crime to hold another person in involuntary servitude. The Kozminskis were also charged with violating Section 241 of the same code, which prohibits conspiracies to interfere with rights secured by the Constitution or laws of the United States. And the conspiracy charged was a conspiracy to interfere with the 13th Amendment right to be free from involuntary servitude. The government relied in part on evidence that the Kozminskis had used psychological coercion to cause the victims to believe they had no alternative but to work on the farm. The district court gave the jury a broad definition of the term involuntary servitude that encompassed situations involving purely psychological coercion. The jury found the defendants guilty of some of the charges, and a divided panel of the Court of Appeals affirmed. The case was reheard en banc, and the Court of Appeals reversed the convictions and remanded the case for a new trial. The Court of Appeals ruled that the district court's definition of involuntary servitude was too broad, and also held that it generally can't exist absent the use or threatened use of physical or legal coercion to compel labor. And the court found an exception to the rule in cases where the defendant uses fraud or deceit to compel services from a minor, an immigrant, or one who is mentally incompetent. We granted certiorari to resolve a conflict among the courts of appeals on the meaning of the phrase involuntary servitude for purposes of criminal prosecutions under these statutes. In the opinion filed today, we hold that absent further guidance from Congress, The term involuntary servitude under Sections 241 and 1584 necessarily means a condition of servitude in which the victim is forced to work for the defendant by the use or threat of physical restraint or physical injury, or by the use or threat of coercion through law or the legal process. We agree with the Court of Appeals that the convictions must be reversed because the district court's instruction on involuntary servitude was too broad. Justice Brennan, with whom Justice Marshall joins, and Justice Stevens, with whom Justice Blackmun joins, have filed opinions concurring in the judgment. In the second case, number 866139, Watson versus Fort Worth Bank and Trust, it comes to us on writ of certiorari from the United States Court of Appeals for the Fifth Circuit. It's an action under Title VII of the 1964 Civil Rights Act. And that law forbids discrimination in employment on the basis of race, color, religion, sex, or national origin. In this case, the petitioner claimed she was the victim of racially discriminatory promotion policies carried out by her employer, the respondent bank. Those policies essentially allowed individual supervisors at the bank, all of whom were white, to use their unguided discretion to choose the person they felt was best suited to receive promotions when vacancies occurred. Our prior decisions have distinguished two theories on which a Title VII plaintiff may proceed. One theory, known as disparate treatment analysis, requires proof that the defendant employer intentionally discriminated against the plaintiff. The other theory, which is called disparate impact analysis, does not require proof of discriminatory intent. Instead, the plaintiff may show that facially neutral employment criteria, which are not sufficiently job-related, have a substantial adverse effect on the protected group. Our previous disparate impact cases have dealt with objective employment criteria, such as high school diploma requirements, standardized intelligence tests, and minimum height and weight requirements. The courts of appeal have disagreed with one another as to whether disparate impact analysis may be applied to more subjective employment criteria, such as those used by the respondent in this case. The court below, applying Fifth Circuit precedent, held the petitioner should not be allowed to use disparate impact theory to challenge her employer's subjective or discretionary promotion criteria. We hold today that disparate impact analysis is applicable to cases like this one, without regard to the objective or subjective nature of the challenged employment practice. The court's opinion with regard to the evidentiary standards to be applied is joined by only 4 members of the court. But the judgment is vacated and the case is remanded for further proceedings consistent with our holding. Justice Blackmun has filed an opinion concurring in part and concurring in the judgment in part, in which Justices Brennan and Marshall have joined. Justice Stevens has filed an opinion concurring in the judgment. Justice Kennedy took no part in the case.
The opinions of the court in 2 cases will be announced by Justice Stevens.
The first case I have to announce is Bowen against Massachusetts, numbers 87712 and 87929. The principal question presented in this case is whether a federal district court has jurisdiction to review a final order of the Secretary of Health and Human Services refusing to reimburse a state for a category of expenditures under its Medicaid program. The answer to the question depends on the meaning of Sections 702 and 704 of the Administrative Procedure Act. With respect to Section 702, the issue is whether an action seeking a review of a decision by the Secretary disallowing reimbursement of these expenses is an action seeking relief other than money damages within the meaning of the statute. Largely for reasons stated in an opinion for the District of Columbia Circuit written by Judge Bork, we disagree with the Secretary and conclude that this is not an action for money damages. With respect to Section 704, the question is whether relief is barred because the state has an adequate remedy in the claims court. And for reasons stated in our opinion, we hold that the claims court remedy is not adequate. Accordingly, we reject the Secretary's arguments and conclude that the district court did have jurisdiction to grant complete relief in this case. Justice White has filed an opinion concurring in the result, and Justice Scalia has filed a dissenting opinion in which the Chief Justice and Justice Kennedy have joined. The second case that I have to announce is number 866169, Thompson against Oklahoma, which comes to us from the Court of Criminal Appeals of that state. The petitioner was convicted of first-degree murder and sentenced to death. The principal question presented is whether the execution of that sentence would violate the constitutional prohibition against the infliction of cruel and unusual punishment because petitioner was only 15 years old at the time of his offense. The authors of the Eighth Amendment drafted a categorical prohibition against the infliction of cruel and unusual punishments, but they did not define the contours of that category. They delegated that task to future generations of judges who have been guided by the evolving standards of decency that mark the progress of a maturing society. In performing the task in capital punishment cases, the Court has reviewed the work product of state legislatures and sentencing juries and has carefully considered the reasons why a civilized society may accept or reject the death penalty in certain types of cases. In this case, the opinions that have been filed all agree with the proposition that there is an age below which a juvenile's crimes can never be constitutionally punished by death. For reasons stated in separate opinions, one filed by Justice O'Connor and the other which I have filed and which is joined by Justice Brennan, Justice Marshall, and Justice Blackmun, we conclude that the death sentence may not be carried out in this case. Justice O'Connor's opinion stresses the fact that every single American legislature that has expressly set a minimum age for capital punishment has set that age at 16 or above. When one adds those 18 states to the 14 that have rejected capital punishment completely, it appears that almost two-thirds of the state legislatures have definitely concluded that no 15-year-old should be exposed to the threat of execution. In my opinion, I review additional evidence of state legislative decisions that draw the line between childhood and adulthood in different ways in different parts of the country. This legislation is consistent with the proposition, based on the long history of our law, that the normal 15-year-old is not prepared to assume the full responsibilities of an adult. We also review the experience of sentencing juries that indicate how uncommon it is for a person under 16 years of age to be sentenced to death. Finally, relying in part on opinions authored by Justice Powell, we endorse the proposition that less culpability attaches to a crime committed by a juvenile than to a comparable crime committed by an adult. We explain why neither of the two principal societal purposes on which the Court has relied to uphold the death penalty, retribution and deterrence of capital crimes by prospective offenders, supports the imposition of capital punishment upon a 15-year-old offender. Because we are not persuaded that the imposition of the death penalty for offenses committed by persons under 16 years of age has made or can be expected to make any measurable contribution to the goals that capital punishment is intended to achieve, its infliction involves nothing more than the purposeless and needless imposition of pain and suffering and is therefore an unconstitutional punishment. Thus, for the reasons stated at greater length in the opinions filed by Justice O'Connor and by me, the judgment of the Court of the Criminal Appeals is vacated. Justice Scalia has filed a dissenting opinion in which the Chief Justice and Justice White have joined. Justice Kennedy took no part in the consideration or decision of the case.
The opinions of the Court in two cases will be announced by Justice Brennan.
The first of the two cases is Communications Workers of America versus Beck, which is here on certiorari to the Court of Appeals for the Fourth Circuit. Section 8A3 of the National Labor Relations Act permits an employer and a union to enter into an agreement requiring all employees in the bargaining unit to pay union dues as a condition of continued employment, whether or not the employees become union members. The petitioner union entered into a collective bargaining agreement that contains a union security clause under which all represented employees who do not become union members must pay the union agency fees in amounts equal to the dues paid by union members. Respondents who are bargaining unit employees who chose not to become union members filed a suit in federal district court challenging the union's use of their agency fees for purposes other than collective bargaining, contract administration, or grievance adjustment. They allege that expenditure of their fees on activities such as organizing the employees of other employers, lobbying for labor legislation, and participating in social, charitable, and political events violated the union's duty of fair representation, Section 8A3, and the First Amendment. The district court concluded that the union's collection and disbursement of agency fees for purposes other than collective bargaining activities violated the associational and free speech rights of objecting non-members, and granted injunctive relief and an order for the reimbursement of excess fees. The Court of Appeals, preferring to rest its judgment on a ground other than the Constitution, ultimately concluded that the collection of non-members' fees for purposes unrelated to collective bargaining violated the union's duty of fair representation. We affirm the judgment of the Court of Appeals. We hold that the courts below properly exercised jurisdiction over respondents' claims that exactions of agency fees beyond those necessary to finance collective bargaining activities violated the judicially created duty of fair representation and also violated respondents' First Amendment rights. We hold further that Section 8A3 does not permit a union over the objections of dues paying non-member employees to expend the funds collected from them on activities unrelated to collective bargaining activities. The case is controlled, we believe, by a decision in Machinist versus Street some years ago. Now, that case involved Section 211 of the Railway Labor Act and not the National Labor Relations Act, which is what is involved in the case before us today. But Section 211 of the Railway Labor Act does not permit a union over the objections of non-members to expend union agency fees on political causes, and therefore Street is controlling because Section 8A3 of the National Labor Relations Act and Section 211 of the Railway Labor Act are in all material respects identical. In the canon of statutory construction, that the same language in two statutes be construed in like fashions is particularly applicable here, where the statutory equivalence reflects the fact that the two provisions were born of the same congressional concerns. Section 8A3 was intended to correct abuses of compulsory unionism that had developed under closed shop agreements, at the same time to require through union security clauses that non-member employees pay their share of the costs of benefits secured by the union through collective bargaining. And those same concerns prompted Congress' later amendment of the Railway Labor Act. Given these parallel purposes, the structure and language of 8A3 and Section 211, both provisions must be interpreted, we believe, in the same manner. Only the most compelling evidence would support a contrary conclusion, and petitioners have not proffered such evidence here. Justice Blackmun, joined by Justice O'Connor and Justice Scalia, has filed an opinion concurring in part and dissenting in part. Justice Kennedy took no part in the case. The second case I have to announce also comes here on certiorari from the Court of Appeals for the Fourth Circuit. It's Riley versus the National Federation of the Blind of North Carolina. The question for decision in the case is the constitutionality of the North Carolina Charitable Solicitations Act. That act regulates professional fundraising and defines the prima facie reasonable fee that a professional fundraiser may charge according to a three-tiered schedule. A fee up to 20% of receipts collected is deemed reasonable. A fee between 20 and 35% is deemed unreasonable upon a showing that the solicitation at issue did not involve the dissemination of information, discussion, or advocacy relating to public issues as directed by the charitable organization which is to benefit from the solicitation. A fee exceeding 35% is presumed unreasonable but the fundraiser may rebut the presumption by showing that the fee was necessary either because the solicitation involved the dissemination of information or advocacy on public issues directed by the charity, or because otherwise the charity's ability to raise money or communicate would be significantly diminished. The Act also provides that a professional fundraiser must disclose to potential donors the average percentage of gross receipts actually turned over to charities by the fundraiser for all charitable solicitations conducted in the state within the previous 12 months. And finally, the Act provides that professional fundraisers may not solicit without an approved license, whereas volunteer fundraisers may solicit immediately upon submitting a license application. And Applease, a coalition of professional fundraisers, charitable organizations, and potential donors, brought the suit against the appellant government officials charged with enforcement of the Act, seeking injunctive and declaratory relief. The district court ruled that the challenged provisions on their face unconstitutionally infringed upon freedom of speech and enjoined their enforcement. The Court of Appeals affirmed, and we in turn affirmed the judgment of the Court of Appeals. We hold that North Carolina's three-tiered definition of reasonable fees unconstitutionally infringes upon freedom of speech. The solicitation of charitable contributions is protected speech, and using percentages to decide the legality of the fundraiser's fee is not, we think, narrowly tailored to the state's interest in preventing fraud. And North Carolina's requirement that professional fundraisers disclose to potential donors before an appeal for funds percentage of charitable contributions collected during the previous 12 months that were actually turned over to charity is also unconstitutional. This provision of the Act is a content-based regulation because mandating speech to the speaker would not otherwise make necessarily alters the speech's content. Even assuming that the mandated speech in the abstract is merely commercial, it does not retain its commercial character when it is inextricably intertwined with the otherwise fully protected speech involved in charitable solicitations, and thus the mandated speech is subject to the test for fully protected expression, not the more deferential commercial speech principles. Finally, North Carolina's licensing requirement as to professional fundraisers is unconstitutional. A speaker's rights are not lost merely because compensation is received, and the state's asserted power to license professional fundraisers carries with it, unless properly constrained, the power directly and substantially to affect the speech they utter. Consequently, the statute is subject to First Amendment scrutiny. Generally, speakers need not obtain a license to speak, even assuming that the state's interest in regulating those who solicit money justifies requiring fundraisers to obtain a license before soliciting. Such a regulation must provide that the licensor will, within a specified brief period, either issue a license or go to court. That requirement is not met here, for the North Carolina Act permits a delay without limit. Justice Stevens joins only parts 1, 2, and 3 of the Court's opinion, and Justice Scalia joins all of the opinion, but not footnote 11. Justice Scalia has filed an opinion concurring in part and concurring in the judgment. Justice Stevens filed an opinion concurring in part and dissenting in part. The Chief Justice filed a dissenting opinion in which Justice O'Connor joined.
I have the opinions of the Court to announce in two cases. In the first of them, Bowen against Kendrick, numbers 87, 253, and others, concerns when in 1981 Congress adopted the AFLA, the American Family Life Act, to authorize federal grants to public or private organizations for services and research in the area of premarital adolescent sexual relations and pregnancy. The Act provides that grantees must furnish certain types of services to adolescents, including various types of counseling and education services. Congress recognized that the complexity of the problems associated with teenage sexuality requires the involvement of religious and charitable organizations, voluntary associations, and other groups in the private sector, as well as government agencies, and therefore mandated that prospective grantees describe how they would involve such organizations, including religious organizations, in the provisions of service under the Act. The Act also provides that federal funds may not be used for certain purposes, including family planning services and the promotion of abortion. In this case, the District Court here in the District of Columbia ruled that the American Family Life Act was invalid both on its face and as applied. The Court ruled that the Establishment Clause of the First Amendment of the Constitution prevented any involvement by religious organizations in the federally funded programs. We now reverse the District Court and hold that the Family Life Act is not invalid on its face. We apply the three-pronged standard first announced in Lemon against Kurtzman, and hold first that the Act has a valid secular purpose of eliminating or reducing the social and economic problems associated with teenage sexuality, pregnancy, and parenthood. As to the second prong of Lemon, the effects test, we hold that the Act on its face does not have the primary effect of advancing religion. The Act does not require that grantees be affiliated with any religious denomination, and the services provided under the Act are not religious in character. We have never held that religious organizations are prevented from being involved in a federal grant program that provide aid neutrally to both sectarian and non-sectarian institutions. Finally, we do not think that the Act violates the entanglement prong of the Lemon test. Although monitoring of grantees will be necessary to ensure that public money is spent in the way that Congress intended and in a way that comports with the Establishment Clause, we do not believe that this monitoring is of such a type that will cause the government to intrude unduly in the day-to-day operations of the religiously affiliated grantees. The District Court also struck down the Act as applied. In regard to this claim, we first find that the appellees have standing to raise an Establishment Clause challenge. As to the merits of the challenge, we conclude that the District Court did not follow the proper approach in assessing the claim that the Secretary is making grants under the Act that violate the Establishment Clause. Although the record contains evidence of specific incidents of impermissible behavior by certain grantees, we remand the case for further consideration of the evidence insofar as it sheds light on the manner in which the statute is being administered. Justice O'Connor has filed a concurring opinion. Justice Kennedy has also filed a concurring opinion in which Justice Scalia has joined. Justice Blackmun has filed a dissenting opinion in which Justices Brennan, Marshall, and Stevens have joined. The second of the two cases is number 87-1279, Morrison against Olson. This case involves a challenge to the constitutionality of the independent counsel provisions of the Ethics in Government Act. This act authorizes the Attorney General to call for the appointment of an independent counsel to investigate and, if necessary, prosecute certain high-ranking government officials for violations of certain federal laws. The independent counsel has significant prosecutorial powers and is appointed not by the Attorney General but by a special court created for that purpose. This case grew out of a dispute between Congress and the administration over whether the Environmental Protection Agency should have to produce certain documents that had been subpoenaed by a House committee during an investigation into the administration of the Superfund law. After this dispute was resolved, the House Judiciary Committee undertook its own investigation into the Justice Department's role in the Superfund dispute. The Judiciary Committee's report suggested that appellee Olson, who was then Assistant Attorney General, had testified falsely before the committee, and that appellees Schmaltz and Dinkins, who were also officials of the Justice Department, had obstructed the House investigation by refusing to turn over certain documents. The chairman of the Judiciary Committee then requested the Attorney General to begin an investigation into whether an independent counsel should be appointed pursuant to the Act. After a preliminary investigation, the Attorney General recommended that an independent counsel be appointed to investigate the allegations against appellee Olson. The Special Division of the U.S. Court of Appeals for the District of Columbia subsequently appointed appellant Morrison as the independent counsel in this case. In the course of her investigation, she caused a grand jury to issue subpoenas to all three appellees, and they moved in the district court to quash the subpoenas, claiming that the independent counsel provision of the Ethics in Government Act was unconstitutional. The district court upheld the Act's constitutionality and later ordered that appellees be held in contempt for continuing to refuse to comply with the subpoenas. Appellees appealed to the Court of Appeals, which reversed the contempt order and ruled by a divided vote that the independent counsel provisions of the Act were unconstitutional. Appellant Morrison then brought this appeal to us. We now reverse the Court of Appeals in an opinion joined by 7 members of the Court and uphold the validity of the independent counsel provision of the Ethics in Government Act. We hold first that it does not violate the Appointments Clause of Article 2 for Congress to vest the appointment of independent counsels in the Special Division. The Appointments Clause states that Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. In our view, appellant is an inferior officer for purposes of this clause because she is inferior in rank to the Attorney General, who has the power to remove her for good cause, because she has limited jurisdiction and carefully prescribed duties, and because the office of independent counsel is of limited duration and tenure. We also find that the Appointments Clause does not expressly prohibit interbranch appointments of the type created by this Act. We hold that the powers vested in the Special Division by the Act do not run afoul of Article 3's limitation on the performance of non-judicial functions by federal judges. Finally, we conclude that the Act does not violate the separation of powers principles embedded in the Constitution by impermissibly interfering with the executive's discharge of his function as allocated by the Constitution. The Constitution, we hold, does not prevent Congress from restricting the Attorney General's power to fire an independent counsel to those situations in which good cause is shown. Here, Congress has not attempted to insert itself in the removal of executive officials, as was the case in the earlier decisions of this Court, such as Bowsher against Sinar and Myers against the United States. We reaffirm the holding of the Myers case that Congress may not aggrandize its own powers by becoming involved in the decision to remove an executive official. But we do not think that in this case the good cause removal restriction contained in the Act unduly interferes with the President's exercise of executive power and his constitutional duty to ensure that the laws are faithfully executed.
I am the one of the 8 who filed the dissent in this case, and I suppose when one dissents from as many of the Court's decisions in one day as I have today, you get to discuss it. I discuss it because I think it's one of the most important opinions the Court has issued in many years. To many people, it may seem that this case is of some political interest, but is not likely, now or in the future, to have any proximate effect upon their lives or the lives of their children. It does not, after all, involve freedom of speech, freedom of the press, freedom of religion, or any of the wonderful guarantees of our Bill of Rights. That is wrong. In the dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. That structure was designed to prevent an excessive governmental power, which is always the first threat to liberty, from coalescing. To achieve that, 2 principles were absolutely central. One was the separation of powers among 3 branches. The second was an equilibration of powers, so that none of the 3 branches could become too strong. For the latter reason, the legislative branch, naturally the most powerful because it is the closest to the people, was intentionally weakened by dividing it into 2 separate houses, differently elected, that would not always agree. And for the same reason, the executive branch was strengthened by giving it a role in the legislative process, the veto power, so that it could defend itself. And also for the same reason, the executive's power, unlike that of the Congress, was not divided, although that had been proposed at the Constitutional Convention. Article 2, Section 1 provides that the executive power shall be vested in a President of the United States. The Court's opinion today does not deny that what is at issue in this case is purely executive power, quintessentially executive power, the power to prosecute for violations of the law. Yet it holds that, despite the Constitution, a statute can enable this power to be exercised by someone who is not entirely subject to the control of the President, a mini-executive, so to speak, with jurisdiction over a very small, although in my view, a very important area. That independent counsel has authority to investigate and prosecute, whether the President thinks it is justified or not, the closest advisors to the President and indeed the President himself. We allow this mini-executive to be created because, in our view, and I quote the Court, the President's need to control the exercise of the independent counsel's discretion is not so central to the functioning of the executive branch, close quote, as to require complete presidential control. To begin with, I disagree with that judgment. I suspect that if a president were asked to list the 10 powers he thought most necessary to protect himself, practically and politically, within our governmental system, the ability to decide whether he or his closest advisors should be criminally prosecuted would surely be among them. Placing this power in someone else has, first of all, an intimidating effect upon his advisors. The present investigation, for example, arose out of a bitter dispute between the executive and Congress concerning the scope of executive privilege. Respondent Olson played a key role in that dispute, after which a committee of Congress conducted a 2.5-year investigation of his activities, including testimony before Congress, and then sent a 3,000-page report to the Attorney General, requesting the appointment of an independent counsel. For reasons I describe more fully in my opinion, the Attorney General probably had no choice but to comply with that request. I do not know, of course, whether Mr. Olson is innocent or guilty of the matters that are under investigation. But I do know that those advising the President and representing his interests in testimony before Congress in the future will, whether they are innocent or guilty, certainly act with a reduced degree of zeal. Taking away the prosecutorial discretion hurts the President, secondly, in a political manner, by eroding his support among the people. Nothing is so effective for that purpose as being able to say that X number of the President's close associates are under investigation or indictment. In the last 2 administrations, 9 highly publicized independent counsel investigations have reduced the political strength of the presidency vis-à-vis the Congress in this fashion. But more fundamentally, it does not seem relevant to me, as it does to the Court, how important the particular element of executive power taken away from the President may be. Even if we were good at assessing that, which today's opinion convinces me we are not, the Constitution did not leave the President's powers at our mercy. It says that the executive power, not some executive power, shall be vested in a President of the United States, not a President of the United States and others. How incompatible what we have done today is with what has until today been our political traditions may be made clear by thinking what the result would have been if a statute had been passed seeking to do the same thing to one of the other 2 branches. Would we have allowed Congress to pass a statute saying that henceforth one tiny bit of the power to enact laws relating to bubble gum, for example, would henceforth be exercised instead of by the House and the Senate, by some new body established by statute? Or would we have allowed Congress to take a tiny bit of the judicial power, the power to hear bankruptcy cases, for example, and give it to tribunals other than Article III courts? The answers are obvious. A little over half a century ago, in a case called Humphrey's Executor versus United States, Justice Sutherland wrote an opinion announced the same day as the case that invalidated the National Industrial Recovery Act, which prevented President Franklin Roosevelt from removing the commissioners of the Federal Trade Commission. That was itself a reversal of our prior law regarding the President's powers. Many, including President Roosevelt, thought it an action motivated by hostility to the President's programs. But Humphrey's Executor preserved, at least in theory, the line that the Constitution established. It allowed the restriction upon the President's power because it found that the Federal Trade Commission did not exercise purely executive power. Today, however, the Court concedes that what we have before us is precisely that. It effectively overrules Humphrey's Executor and says that in the future, how much power can be taken from the President will depend upon, quite literally, our case-by-case evaluation of whether what has been taken from the President is too much. I do not think we are qualified to decide that. More importantly, I do not think we are authorized to decide that. All of us are familiar with and proud of the phrase that we think epitomizes our political system, a government of laws, not of men. Not many know where that came from, which is part the first Article 30 of the Massachusetts Constitution of 1780, which reads in full as follows: "In the government of this Commonwealth, The legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them. To the end, it may be a government of laws and not of men. That is how central the founders of our republic thought the separation of powers was to our system. That is what achieves the end, that it is a government of laws, not of men. And as the founders knew, separation cannot be preserved without equilibration. Today's decision, which departs from the text of the Constitution and gives no reason for the departure, except that a majority of this court does not think that the power taken away from the President was too much, is not, in my view, the operation of the government of laws that the Constitution intended. Indeed, it does not seem to me to be the operation of a government of laws at all.
Justice Kennedy took no part in the consideration or decision of that case.